name is Abdiyahya Abdul. My matric number is 266490. So today I would like to present you one of the biggest financial fraud in Southeast Asia. So I would like to present you the background of the company, which is Hing Leon, established in Singapore in 1963. So Hing Leon is an integrated downstream energy group offering a comprehensive and efficient mix of resource and global market. So the regional presence is built by oil trading, terminal link and storage, bunker supply, lubricant, grease manufacturing, inland transportation service, and diesel relating, marine logistics and support. So in 2012, the company's reached a revenue of 14 billion. So that's all for the background of the company. I would like also to continue the scandal of the for the financial scandal of Hing Leon trading. So the first scandal was when the Hing Leon last year imploded their oil cost branch set off as the default that uncovered a long stretch of stupid way misfortunes and affirmative misrepresentation away of the author of the Hing Leon, otherwise called OK Lim, just as also child even Lim Ji So and his little girl of Shin. The second was when the BWC asserted they breached their trustee. So Nin and his two kids are embarrassed by 3.5 billion obligation and 90 million of profit that they purportedly paid themselves despite the fact that their organization was ruined. So PC asserted that they breached the trustee obligation as chief and engaged in forced exchanging. The third one is the supposed fake action included. So the production of the imaginary increase of this dispute, collective exchange, and different misfortunes, the implementation of archive, the control of Hin Leon record through its bookkeeping passage, the execution of Hin Leon stock, and the acquiring of financial through ill-advised means. The fourth one is the HBCU. HBC is Hin Leon's biggest loan post with about 6 million owning. Likewise, made of legitimate move against the family and trail of the Bank of China, as Brigades expressed at the court failing last year. DBS and ABN Armor Bank and also OCBS Bank are owed by 200 million and 300 million of each, respectively. One is the problem that made the Him New family during the Monday hearing. So, which is Lim family had a problem with the legal achievements of being delegated outlets, referring to the incredible situation that they will be not have an option to impartially serve as a legal supervisor judge. All things being equal, the family proposed Mr. Henry Tan and Mr. Chen Yi Hon from next TS as the company funders. The second scandal happened when the funders proceed with the claim against the Lim family, gather accounts receivable from counterparties, and discard of union leftover resource, including a modern structure of the Playfair Road. ST gets it. That's all. Thank you, Doctor.
Hello everyone, my name is Kwang Ming Chen, number matrix 279404. In June 2021, Helium Trading Limited was suing Deloitte as Deloitte failed to detect significant irregularities in Helium's financial statements. There are two statements claimed within the suit case toward Deloitte, which are: Deloitte failed to detect the irregularities and the material misstatements, and Deloitte acted in breach of the terms of each engagement with the plaintiff. These two statements claimed by the High Court of Singapore will be discussed as follows based on the related auditing standard. So what is the irregularity in this case? Referring to the case of Hin Leong Trading Limited versus Deloitte, the irregularities refer to the deceitful trading and unlawful actions by the directors and former managing director of Hin Leong, especially the significant understatements of the company's asset. Based on the International Standard of Auditing 240, an auditor is given the responsibility to detect the irregularities of the financial statements and ensure reasonable assurance that the financial statements are free from material misstatements that are caused by fraud or error. An auditor should also possess the value of professional skepticism during conducting any audit procedures. Referring to ISF 240, a systematic audit procedure needs to be established to identify the risks related to irregularities or fraud. Firstly, the auditor should execute the procedure to collect information from the related parties, for example, management, and those charged with governance. Secondly, the auditor is required to identify the risk in the level of financial statement and the level of assertion, and those assess risks that could contribute to fraud. Thirdly, the auditor is required to establish an overall response for the assessed risk of material misstatement due to fraud at the financial statement level and also the assertion level. Next, the auditor needs to establish the audit procedures if the risk is related to management override of controls. Regardless of the assessment of the risk overriding controls by management, the auditor should also examine the appropriateness of the accounting record, for example, the journal entry, and review the accounting judgment of estimates for buyers, and lastly, investigate significant transactions that are considered abnormal. After that, an overall conclusion needs to be provided based on the evaluation of the audit evidence. And then, written representations from management and those charged with governance need to be obtained by the auditor. If any fraud or any indication is identified, the auditor is required to communicate to management and those charged with governance.
Hello, my name is Noor Alia Zaida binti Mazahar, metric number 273460. I will continue the presentation. What are the material misstatements in this case? Referring to the case of Helium Trading versus Deloitte, the material misstatement refers to information in the financial statement that is educatively incorrect. Helium Trading claimed in the suit that Deloitte made material misstatement that lead to several parties and stakeholders being very deceived as to the financial performance and financial liquidity. Next, what is the auditor role in determining the materiality of the misstatement? Based on ISA 315, the auditor is required to identify the risk of material misstatement through an established audit procedure. The things that should be added into the risk assessment procedure are investigation of management and other parties within entity. Next is analysis the procedure. Then, the auditor must observe an inspection to identify the risk of material misstatement. Next, based on ISA 450, the auditor is required to collect misstatements identified during the audit other than those that are clearly frivolous. Then the auditor established a monetary standard below which misstatements are considered obviously frivolous. Lastly, the auditor roles in determining the materiality of the misstatement is the auditor must make a judgment whether the misstatements are considered significant individually and collectively. The evaluation of materiality because the initial materiality might be not appropriate based on business actual performance.
Good day everyone, my name is Gao Hui-Jin and my metric number is 277374. I will continue the presentation with the discussion of the role of an auditor in the Deloitte Act in breach of the terms of an engagement with the plaintiff. Firstly, let us discuss what is an audit engagement. So, an audit engagement is a contract between a third-party auditor and a client to perform an audit of specific component of the client business, such as financial statements, information system, internal controls, and so on. According to ISA 210, the terms of the audit engagement must be agreed with between the auditor and management or those who oversee governance, and the agreed terms shall all be included in an audit engagement letter or other suitable forms of the written agreement. The objective of an auditor is to accept or proceed with an audit engagement once the basis on which it will be conducted has been agreed upon. The auditor's overall objective in performing a financial statements audit has been stated in ISA 200, which is to obtain reasonable assurance that the financial statements overall are free from material misstatement, by that allowing the auditor to convey an opinion on the prepared financial statements. The second objective is to disclose the financial statements and communicate in compliance with the auditor findings. In addition, when determining the procedures of an audit to be done, the auditor can refer to the scope of an audit stated in ISA 200, which refers to the procedures of audit that are considered appropriate to meet the auditor objective in the auditor judgment and based on the ISA. Next, we will discuss what is breach of contract. Auditors and clients have a contractual connection. When an auditor fails to fulfill a contractual obligation, it is considered a breach of contract. Parties to a contract can file a lawsuit as a result of a breach. According to the case of Hin Leong versus Deloitte, the breach action that demonstrated by Hin Leong is Deloitte failed to identify a material error or employee fault in its financial statements for more than a decade. Deloitte as the auditors may declare that they used due professional care by the contract, that the client was contributory negligent, and that the breach did not cause the client losses.
Okay, next we go through the impact on an auditor. Okay, first the common law. The financial statement is misleading. So maybe either the third party or the client face the loss. Okay, in this situation, the third party is the investor, banker, and the others creditor. If the auditor found guilty under breach of common law, they can the penalty is need to fix the damage, but it must come up with three things before they can fix. First, the auditor must own the plaintiff duty of care. Second is the auditor needs to plead a guilty or tak boleh. 1, 2, 3. The auditor must plead the guilty of their negligence, and third is the plaintiff need have the proof that they are suffer of the auditors on the auditor's care. So in this situation, we can see the Hong Leong company audit almost 20 bank and lost about 808 million US dollar. I mean 808 million US dollar and in trading and 3.5 billion US dollar in asset. However, if the court found guilty, if the auditor have the intention to make a crime, they can the penalty is fine and imprisoned. But fine at the same time, for those who purchase the security from the Hong Leong trading, they can sue that auditor because of the material misinterpret. Based on the Security Act 1993. Okay, back to the penalty. If the court is found guilty, the penalty they can give is in prison not exceed than 5 years, or they need to pay the fine. Maximum is 3 million ringgit Malaysia. However, sometimes they need to pay both. One is pay the fine, and second they need to go to prison. It based on the situation that court if the court see they have a lot of situation that they need to cover it. So that's all from me. We proceed to the next presenter.
A very good day to everyone. My name is Shaldo Izaidi and my matrix number is 264179. Now I'll be presenting about the conclusion part of this case study. So what we can conclude from this case study is that audit failure can harm an audit firm's reputation and have a variety of negative implications, such as loss of profit or can be sued by the company they are auditing. Moving on to the next point is the audit firm will lose their potential customer. So if this happens, the clients uh, that have a negative thought about the firm will move to another firm, and this will make the audit firm lose their or downgrade their profit. Now moving on to the third point is that Deloitte, the company in the audit firm in the case study, which is Deloitte, must take seriously the principle that they should apply to their job. The principle that they should take is such as trustfulness, competitiveness, compatible, relevance, and etc. If they take this principle seriously, I don't think that they will perform and fail in their audit, and this also will make the customers or clients feel trusted to them. So the last point is that Deloitte must enable creative accounting methods that devalue or even undermine auditor judgment. Auditors are likely to be viewed as being at fault, so they have to perform a creative task to make the clients believe them.